So we're going to proceed just like a normal hearing would take place.
So for the record, I'd respectfully ask to read into the record the Florida Bar Oath, which includes supporting the Constitution of the United States and the Constitution of the State of Florida, among other things. It does not include supporting administrative rules. May I read that?
No.
For the record, I'd also like to state that in a previous trespass appeal hearing in Charlotte County, the magistrate asked the county attorney if the magistrate was required to read county ordinances as though they are constitutional and reconcile them with the Constitution in making his determination. The county's attorney's answer was, it is.
This is, again, an appeal of trespass, and we are going to show through Deputy Sterling and 2 videos that trespass is properly issued. Deputy Sterling is going to testify that he was authorized by the county administrator, and he was requested by the county administrator to issue a trespass warning for any violation of facility rules that he personally observed. Deputy Sterling is going to tell you that he was on duty on a certain day, I believe it was June the 13th. He was not at the front desk. He was observing the cameras in a room, looking at the cameras, saw Mr. Kesselring walk in with what appeared to be a ball cap mounted camera. Didn't appear to be disturbing anybody, going about his business, going down the hallway to pick up some public records. That Deputy Sterling went to the public records office where he saw Mr. Kesselring, asked him, are you recording? The response was absolutely.
I follow the Creator and not a man-made laws that go against His laws. My Creator's given me certain unalienable rights. I'm not a citizen of this world, but a citizen of heaven. But I must try to live at peace with all men. The best way I see fit to function is to not hinder anyone else's rights or allow them to hinder mine. So on June 12th, 2019, at approximately 3:15 p.m., a trespass warning was issued in my name by Deputy Randall Sterling. It was a trespass warning from public areas of the public county administration building and the entire public campus of the public administration building, including the public sidewalk in front of the public building, for a year. This trespass was given for allegedly videotaping a transaction I was allegedly making while lawfully picking up some public records from the Public Records Office from a public records specialist. A transaction with government was documented for valuable information for the public to be disseminated at a later time. This trespass was executed under a rule made up by the county attorney that is being implemented as though it is law. The county commissioners are well aware of this rule and have not seen fit to either challenge or confirm it through public notice or public input. According to the officer, it was alleged I was trespassed for videotaping and for disruptive, harassing, or unsafe behavior, including conduct which interferes with county employees or county officials in the performance of their duties or interferes with proper use of the county facilities by others. This is Rule 7 and Rule 9. The evidence will show that the person in the video should not have been trespassed, disrupted, harassed, or treated in a way that was unsafe to himself or to his constitutionally protected rights by the deputy or any other county employees. I have a genuine desire and an intent to return to the Charlotte County Administration Building, not only in my capacity as a resident of Charlotte County, Florida, but also in my capacity as a citizen of the state of Florida who attempts to instruct my public officials on a regular basis, also as a citizen who frequently attempts to access public records, and even as a journalist and a disseminator of information to the public of materials that would be of interest to them.
Would you state your name and spell your last name, please?
Randy Sterling, Sterling.
And where are you employed, sir?
Charlotte County Sheriff's Office.
By the way, what jurisdiction or what branch of the government do you fall under? You don't know which branch? No. Somebody else, county attorney or Ray Sandrock or?
Well, I wasn't listening. What did you say?
I said, who told you you're trespassing?
Me.
You're just doing it on your own. And why is it you're trespassing again?
You're recording.
Because I'm recording while I'm doing business, recording my
transaction with the government because I don't trust them, and you're trespassing me for that, correct? Sure. Okay. Silly rules, it's your conduct, silly rules don't override law, and you're supposed to be law enforcement, you're supposed to be keeping an oath. Mm-hmm. You're supposed to be protecting and serving our rights in the Constitution. And serving you with the trespass. Yeah, I know. It's a violation of your oath, sir.
This is going to be Mr. Kesselring's Exhibit 1, which looks like a oath of office.
I, Randall Sterling, do hereby solemnly swear or affirm that I will support, protect, and defend the Constitution and government of the United States and the state of Florida, that I am duly qualified to hold office under the Constitution of the state, and that I will well and faithfully perform the duties of Deputy Sheriff of Charlotte County, on which I am about to enter, so help me God.
Do you believe you should support and defend the First Amendment of the Constitution? Have you ever read the First Amendment?
Not in its entirety.
Okay.
But if you feel he didn't comply with the ordinance, or did something procedurally incorrect in applying the ordinance, you can ask him about that. But as far as his legal oath, the Constitution, whether he violated any laws, that's for me to decide.
Where were you when, I already got it, but let me clarify, where were you when you decided to trespass me?
Chief Security Coordinator's office.
Can I have the name of the security coordinator?
Yes, and relevant.
Do you know the name?
The county doesn't have one at the moment.
Okay. Is there a policy? Is there actually a set policy on how to trespass people?
There isn't.
What is it?
I mean, it's multiple pages. I can't recite it to you.
Who's supposed to sign these trespasses?
Issued to the public?
Yes,
I mean, it varies in each circumstance.
it does. How can it vary? Why would it vary? Our people are all the same. I'm sorry.
The county administrator, his designee,
Okay.
that's how it's worded.
Well, then why would you have to interrupt him to get his signature for another trespass? Did you witness the person in the video doing anything disruptive on 612 at anywhere in the building?
No.
Disruptive. Did you witness this person harassing anybody?
No.
Did you witness this person behaving unsafely?
No.
Did you witness this person interfering with county employees or county officials in the performance of their duties?
Not directly.
Is that a no?
Sure.
Okay. Did you witness me interfering with the proper use of county facilities by others?
Say again?
Did you witness me interfering with the proper use of the county facilities by others?
Like, as in you were bothering other people?
No, just like I said, because that's in the trespass. That's rule number 9 that you trespassed me for. For interfering with the proper use of county facilities by others.
No.
No, thank you. Did you witness me doing anything in rule number 9? Those were all the items in rule number 9.
No.
No, thank you. So why did you check off that I violated rule number 9?
Consistency,
Consistency.
and you interrupt county business when these matters have to be dealt with.
Really? Okay. Consistency. That's interesting. So, do you believe that do you believe that trespassing me for rule number 9 or trespassing anyone for rule number 9 is a truthful statement?
I object to that question. Well, his personal beliefs are irrelevant.
Oh,
Was it a truthful statement?
Out of consistency with others and disrupting county business and having to deal with the issue.
So, somebody was trespassed for rule number 7 and 9, and the deputy just admitted that they did not violate any of 9.
Yeah, please.
Sure. Does law enforcement enforce rules or laws?
Laws.
Just laws. Thank you. Okay. And you took an oath to the Constitution. Do you take an oath to the people that are giving you these orders, the county attorney?
I object to that relevance.
answer the best you can.
No.
Mr. Kessering, the county has rested their case. Now is your opportunity, if you would like, to present any witnesses or any evidence you'd like to present.
This is a statement from the state attorney that we have the right to do that and makes that law null and void. So do all the other ones, but.
I'll consider that as argument later. So I will take judicial notice of every applicable law, from the Constitution to the Bill of Rights to the First Amendment to Florida statute.
I have a memorandum from Ray Sandrock to county employees, and I believe he's telling them to violate the law.
Let me say this,
Yeah.
Mr. Kessering, county's gonna go first.
Was the warning issued by an authorized person? The answer I suggest is yes. We heard the testimony from Deputy Sheriff Sterling where he said that he had a conversation with Ray Sandrock, the county administrator, who's empowered to delegate that decision. He delegated it to Deputy Sterling. Clearly, he was videoing in violation of the rules. It's really a strict liability violation. And it doesn't matter. Mr. Kessering, by all measures, appears to be law-abiding, that he wasn't disrupting. That portion, I would agree, is very, very weak as far as the disruption that he caused by videoing. He wasn't confrontational as he did it. He was a gentleman in the hallway. He was a gentleman with Mr. Wintercorn, but he still can't record Mr. Wintercorn or that transaction. And the offense was the actual violation of Rule 7, videoing in the building when the rules clearly showed he was unauthorized.
Let me set you point blank. Are you sticking with the Rule 9 violation?
No.
I would like to move that we strike the witness's testimony on the video. He told an untruth about G4S. He also told an untruth about number 9 when he crossed that off on the rule for consistency.
No, I'm not going to go back and strike any testimony.
I know you mentioned in a previous time that you'd listen to constitutional arguments. So, the First Amendment to the United States in regards to the first supposed violation checked off on the trespass issue, which is rule number 7. The First Amendment, just really part of it, Congress shall make no law abridging the freedom of speech or the press. And just to support the original intent of the First Amendment, I'd like to read a quick quote from Patrick Henry. He was in the ratification convention in the beginning, and they were talking about the First Amendment. And he said, "The liberties of the people never were nor ever will be secure when the transactions of their rulers may be concealed from them. The most iniquitous plots may be carried on against their liberty and happiness." This was an argument for the First Amendment, for all the amendments. The facility rules employed by Charlotte County government, written by Charlotte County Attorney Jeanette Knowlton, her staff, and others, with knowledge of the Charlotte County Commissioners, to stifle the constitutionally protected activity of videotaping, is a direct and blatant violation of the First Amendment. The county can't just do anything they want. They have to follow rules. There are some rules they need to follow. The Charlotte County Facility Rule 7 is unconstitutional on its face and as applied because it impermissibly infringes on the clearly established rights to gather information about what public officials do on public property, and specifically the right to record matters of public interest as protected by the First Amendment, which is incorporated against the states with its subdivisions by virtue of the 14th Amendment. I'll not ask the magistrate to rule on anything new, but simply use the Constitution and reinforcing case law to make your decision justly. That's all I'm asking. I have Smith versus the City of Cummings, which I'm sure you're familiar with.
I have that case.
You're good? You need it?
No, I've got the same case.
Yeah. Year 2000. It was heard by our own United States Court of Appeals, the 11th Circuit. That's us. It is binding. The following is a broad holding, if not the broad holding. The First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. Okay? Any person or attorney that argues that public officials are only elected politicians like county commissioners, I believe is using fabrication. Smith versus City of Cummings was about the filming of police officers. I don't know if police officers are elected elsewhere, but they weren't elected in that situation, and In that most important case, they were not elected, they were public employees, okay? Furthermore, if any person or attorney would like to argue that this is only applied to law enforcement officers, realize that part of the video in evidence is a digital video recording of a law enforcement officer. The same law enforcement officer that was here today as a witness. The fact that filming was not only done of public officials, but specifically of law enforcement officer, makes the case fit perfectly within Smith versus Cummings. Just to clarify, our rights don't come from case law or even the Constitution, they come from our Creator. Hopefully you know that. But they're natural to us. That's why this would seem so unnatural to most people. But it's also protected by, the right is protected by the Constitution. And I'm using case law for your sake. And the First Amendment protects the right to record government employees engaged in public duties. Recording government officials engaged in public duties is a form of speech through which private individuals may gather and disseminate information of public concern. This is exactly what's being done on the video that's been offered as evidence. This can be seen from start to finish on this entire video of a transaction with Public Records Office. Information was being gathered about what public officials do on public property. These activities were, as they would say, videotaped, not only for documentation, but also to express to the public. This was done in public buildings where the public was free to come and go, and public officials were being documented. The right to film was being expressed. This was also being done to monitor public employees to ensure they're doing the right things for the public. A public transaction was being documented for the purpose of expression at a later time. The video entered into evidence was captured from YouTube. The transaction video of the transaction had been expressed at a later date. A transaction was being documented. This was specifically mentioned back in the day by Patrick Henry. The specific word transaction was used. The commissioners, Ken Doherty, Bill Truex, Stephen R. Deutsch, Chris Constance, and Joe Teseo, their attorney, Jeanette Knowlton, and their county administrator, Ray Sandrock, cannot, with a whimsical stroke of a pen, unbind binding case law for any reason. More importantly, these same people cannot abolish or even suspend any part of our United States Constitution. I move this trespass be dismissed. The rule being imposed is a blatant violation of the Constitution and binding case law.
Yeah, no, I'm not going to agree.
Okay, thank you. Okay. Since I don't get the last say, I'm going to have to do some more. I was going to cut it out, but I'm only guessing that my opponent may argue time, place, and manner. And just in case, this facility rule created by the county attorney and others also violates even the exceptions that the courts have created in their belief. They have the authority to restrict our constitutional right to document public officials in public places. In other words, Charlotte County has gone way past the restrictions put upon the people by the courts. According to the courts, my First Amendment rights described above, that I just described, are subject to reasonable time, manner, and place restrictions. The Charlotte County facility rules are an unreasonable restriction. For said restrictions to be reasonable, they must be content neutral, tailored to a legitimate government interest, not broader than necessary to accomplish said interest, and must leave open ample alternative channels of communication. All four conditions must be met. The county has not shown that it has a legitimate interest in restricting video recording within public buildings where the recording doesn't obstruct or impede the orderly operations of the county. The video of the trespass in question speaks for itself. It neither obstructed nor impeded anything. Nor could the county likely show a legitimate interest in restricting such recording, as no public official acting in performance of their official duties has an expectation of privacy. I don't take too much credence again in the case law, but since most lawyers do, I'll cite some. Department of Ag and Consumer Services versus Edwards. It's the District Court Appeals of Florida, 1st District. It's for argument. Would you like that case?
Sure, if you want to.
Okay. So, an officer with the Florida Department of Agriculture Inspection Division, who was not an elected official, was placed under arrest for recording conversations between himself and other public officials, his superiors, Pittman, O'Brien, and Wells. This arrest was supposedly for violation of the Florida statutes regarding interception of oral communications. Well, the Florida Constitution contemplates that public business is to be conducted in the sunshine. This is from the case. Reasoning from this open government premise and the fact that all persons claiming an expectation of privacy in this case were public employees acting in furtherance of their public duties. The hearing officer concluded that any statements made by Pittman, O'Brien, and Wells in performance of their public duties were not privileged, hence no reasonable expectation of privacy attached to those statements. For the record, these were not elected officials. They were public employees. Any person or attorney that would argue that public official is only an elected politician like county commissioners using fabrication as an argument. While I am at it, I would like to add a little more documentation to the definition of public employees. From the Rogache thesaurus, if you'd like me to show you, the synonyms are public official, public servant, public functionary. None of those other people are elected. And from the Cambridge Dictionary, this is a definition: a person who has official duties, especially in a government or even a political party. So there's a sentence here they use: the visitors were met by a functionary who escorted them to the director's office. Maybe the director might have been elected, but I'm sure the person escorting him wasn't. Government functionary, even that has government ministers, as he mentioned, and civil servants. So from some other quick and easy searches of the internet, I don't even take them, but synonyms for public official: public officer, government employee, bureaucrat, an administrative officer, a public official. Could be any of these and more. Of course, the strongest argument is that Smith was filling in police officers that were not elected officials. They were government employees. To reiterate, the county government could show no legitimate interest in prohibiting filming in public buildings. There's also no way the county could show a legitimate government interest in stopping anyone from documenting transactions and legal activities on public property in the most dependable and efficient manner available to them, which would be videotaping or digital videotaping. Further, no citizen has any expectation of privacy. No citizen does either, in things they knowingly expose to the public. So if a citizen doesn't and public workers don't, nobody does in that building. So members of the public have no expectation of privacy in the halls of a public building. If another person creates a disturbance or harasses another person because they don't like a camera, the person doing the actual disturbing or harassing should be trespassed. This includes public employees. Again, there should be no need for case law, as any prudent person that lives in our current world knows there's cameras everywhere, especially at the Charlotte County Administration Building. You have no expectation of privacy in things you normally expose to the public, even in your own home office. When you walk into the public building, you just can't claim an expectation of privacy. Katz versus U.S. This was in regards to private, Conversations, this is a quote, conversations in the open would not be protected against being overheard, for the expectation of privacy under the circumstances would be unreasonable. And then this was a landmark Supreme Court case, just for your information. For the Fourth Amendment protects people, not places. What a person knowingly exposes in the public, even in his own home or office, is not a subject of Fourth Amendment protection. So they're not protected from anything. As such, prohibiting recording in areas of public buildings in which the public is free to come and go would not meet any legitimate government interests. Furthermore, even if the county could argue that it has legitimate interest in barring recording and gathering information on government activities which do not interfere with its operations, it could not likely show that such a restriction as written does not infringe substantially more speech than necessary to accomplish said interest. How is video recording in and of itself a deterrent to any legitimate government interest? Lastly, assuming, just for argument's sake, there was a legitimate government interest and that it did not infringe upon substantially more speech than necessary, such a restriction fails to leave open ample alternative channels of communication. This is Alvarez versus Civil Liberties Union, and it's in the Seventh Circuit. It's just for argument. Audio and audio-visual recording are uniquely reliable and powerful methods of preserving and disseminating news and information about events that occur in public. Their self-authenticating character makes it highly unlikely that other methods could be considered reasonably adequate substitutes. This rule leaves no ample alternative channels, the rule in Charlotte County. We aren't even allowed to access any of the many cameras already permanently installed in the county building that videotape every move we the people and most of the government employees every minute of every day in Charlotte County Administration Building. Even if we had access, there's no audio. That is my first point. Point 2, the Constitution of the State of Florida in regards to the first supposed violation. The trespass rule created by county attorney and being implemented as though it is law also violates Florida state constitution. This is Article 1, Declaration of Rights. Freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. This explains the rights of the people, and I'm sure I'll hear no illegitimate arguments as to abuse or defamation. Our right to videotape is not only protected by the U.S. Constitution, incorporated by the 14th Amendment upon the state, but is protected directly by the Florida Constitution. It also protects the right to assemble. The people shall have the right to peaceably assemble, to instruct their representatives. There's no obstruction to this in the state constitution. They're not allowed to obstruct my right to instruct my representatives, which they're doing. And to petition for redress of grievance, same thing. There are no restrictions. Clearly obstructs these rights. Furthermore, our right to videotape in public buildings has been strongly reinforced by our own state attorney. In reply to a Punta Gorda felony warrant request directed at a person videotaping in a public building, which Punta Gorda Police Department tried to sell as wiretapping, Richard T. Simpson of the state attorney, 20th Judicial Circuit, replied, after saying it wasn't a violation, a citizen's right to film government officials in the discharge of their duties in a public place is a basic, vital, and well-established liberty safeguarded by the First Amendment. This is what our own state attorney said about filming in buildings. This warrant was in regards to filming of Phil Wickstrom, Human Resources, who is a public employee in Human Resources. To repeat from Department of Ag versus Consumer Services, the Florida Constitution contemplates that public building businesses to be conducted in the sunshine. Okay. State statute. As Charlotte County Ordinance 2016-027 makes no mention whatsoever of videotaping, the direct changes made by the facility rules in an attempt to revise or amend Ordinance 2016-17, it is an attempt. The facility rules start with the statement, the following conduct is prohibited by County Ordinance 2016-027. This is an attempt to revise or amend that ordinance by the county attorney and others in violation of the Florida statutes. It says procedures for adopting ordinances. Each ordinance or resolution shall be introduced in writing and shall embrace but one subject and matters properly connected therewith. The subject shall be clearly stated in the title. No ordinance shall be revised or amended by reference to its title only. Ordinances to revise or amend shall be set out in full the revised or amended act or section or subsection or paragraph of a section or subsection. The original county ordinance adopted by the commissioners has no prohibition of constitutionally protected videotape, has no permission for the already constitutionally protected right to videotape outside the building. And I don't know if you knew that from the last case, but we have permission, even with all this other stuff, to go ahead and film outside the building. This was added by the county attorney and others contrary to the procedures in the Florida statutes. I propose this was a revision or amendment to the county ordinance. It was not originally included in the ordinance or in the original facility rules, but is now included in the facility rules. The facility rules begin with only the title of the ordinance. As stated in 166.041, no ordinance shall be revised or amended by reference to title only. From my understanding of the facility rules were written by county attorney, her staff, and others, and never was a revision or amendment to the ordinance ever set forth by our elected commissioners. No vote was taken by our county commissioners. The memorandum. Okay. It was written by the county attorney and others and never brought before the public by the commissioners. Charlotte County government has given training to their employees to violate the rights of the people to gather information about what public officials do on public property. They also distributed special cards to their employees that instructs them to act like they're upset about video cameras by telling the person behind the camera, the one who they are supposed to be serving, that they don't give their permission to post the information being gathered about what public officials do on public property to be shared by other taxpayers. The biggest problem with this thing, the most obvious violation, if a facility supervisor is not available, call 911. This is entirely and absolutely illegal. 911 is only for emergencies. There's no emergency here. This is a crime under Florida Statute 817.49. Whoever willfully imparts, conveys, or causes to be imparted or conveyed to any law enforcement officer false information or reports concerning the alleged commission of any crime under the laws of the state, knowing such information or report to be false, in that no such crime had actually been committed, which it hadn't, shall upon conviction thereof be guilty of a misdemeanor of the first degree, punishable provided in S. 775.082 or S. 775.083. Ray Sandrock and his assistant Kelly Shoemaker have ordered all employees to commit crimes. The moment they call 911, they are calling to report a crime. Photography is not a crime. Now the facility rule itself. In the actual ordinance, Section 3, it states severability. There isn't one in here. I'm not going to go through that. Again, underlined in bold is stated, the following conduct is prohibited by County Ordinance 2016-027. Videotaping never mentioned in the ordinance. The ordinance mentions facility rules, but since the unconstitutional prohibition of videotaping is not included in the original ordinance and was created by the county attorney, it's circular. I don't know what the term would be legal, but if this is upheld, it would give the county attorney unfettered power to make up anything she likes, including no Kessel rings, no dissenting opinion allowed, or even no blacks allowed. If you notice from the copy of the facility rules included in the evidence directly from Jeanette Knowlton, the facility rules were adopted June 28th, the same day that the actual ordinance was adopted. At the bottom you can see the date amended is May 6th, 2019. This amendment substantially changes the ordinance by putting anyone with a video camera or even a smartphone in danger of being disturbed and harassed by a county deputy and issued a trespass warning. This substantial change was done without input from the county commissioners or the public. There is no mention in the original ordinance about audio or videotaping. It only mentions actual crimes and things that might harm others, not tools to document what public officials do on public property. Further, even if it had been included in the original county ordinance, the county ordinance cannot override the U.S. Constitution, the Florida state constitution, or established state law of any kind. County charter. I'd like to discuss that. There's various violations of the charter in the creation of these new facility rules. A prudent person, Your Honor, would conclude that a magistrate would have the authority to rule on county matters, as this rule has been rented by the county. The building in which this room is located is controlled by the county. The magistrate is paid by the county, I believe, and hired by county attorney who wrote the rule in question. The trespass has been issued by the county and the rule is made by the county. Section 1. Charlotte County shall be a home rule charter, county, and except as may be limited by this home rule charter, shall have all county and municipal powers of self-government granted now or in the future by the Constitution, not inconsistent with general law. A prudent man would conclude that a magistrate in a county administrative trespass appeal hearing would certainly be able to rule on the constitutional standing of a county rule being implemented as though it is a law. The legitimate powers have been granted by that Constitution. Smith versus City of Cummings clearly establishes the constitutionally protected right to film in public buildings. The facility rule prohibits the same, violating the people's constitutionally protected right. The chain of command for making legislation, especially legislation so obviously violating the protected rights. The adoption of all ordinances shall require the affirmative vote of a majority of the total membership of the Board of County Commissioners. It was pointed out clearly in my previous point that the ordinance has been substantially changed by the county attorney. She has no authority under the county charter to change, create, or revise an ordinance. She has done so in the creation and changing of the facility rules. Any new rules not coinciding with the original county ordinance that she has created or changed are illegitimate and unenforceable. Furthermore, even if this rule was constitutional, how can anybody but the commissioners create a new crime, a new class of crimes, and new criminal penalties for these crimes? The county attorney's office is not a legitimate body. The county attorney's office does not stand alone over all other branches of government. This should be known by anyone that's ever heard of the term separation of powers. Of course, the second part of the trespass rule is an outright lie. It's not true. I don't need to go through that, so I'm going to skip that. Again, I'm not a trained lawyer, but I'd like to argue a little bit about this arbitrary and capricious, which goes to this rule. Doing something according to one's will or caprice, and therefore conveying a notion of tendency to abuse the possession of power. Arbitrary, according to Black's Law, revised 4th edition, which I have here, 4th edition, means in an arbitrary manner, as fixed or done capriciously or at pleasure, without adequately determining principle, not founded in the nature of things, non-rational, not done according to reason or judgment, depending on the will alone, absolutely in power, capriciously, tyrannically, despotic, without fair, solid, and substantial cause. That is, without cause based upon law. And it isn't. It's not based on law. They do it differently every time. Who knows? Who even knows how it's going to be done? The abuse of discretion or otherwise not in accordance with law, or if it was taken without observation of procedure required by law. Arbitrary, vague law. Sometimes this rule implemented as though it's law. It's applied. Sometimes it's not applied. Sometimes it is.
I'm not objecting to the video, but at this stage, I'm not sure that I've heard a whole lot of argument as far as the evidence, and we take a position that the constitutionality and these issues that you've raised are outside the scope. I mean, I'm happy to I didn't know if you're waiting for an objection from me.
No.
I'm happy to sit here and just have a standing objection to any of
I'll note your standing objection.
I'm getting near done. You want me to finish?
I want you to just finish your arguments.
Okay.
That's what I thought.
Sometimes it's implemented in certain circumstances, and sometimes not, even when the rule was broken 4 times as much by somebody else, so you just don't even know what they're doing. I have a video that I have entered into evidence with 4 gentlemen. I didn't, but a short time before my transaction, had entered the administration building to videotape. Deputy Sterling told them they were breaking the rules. He called the county attorney, who stated, according to the deputy, that she would pass on the trespass. She'd pass on it. The deputy said, have fun. These were 4 people with cameras, and they shouldn't be trespassed, but neither should anybody else. I had a stack of emails, and the county attorney resulted from my attempts to simply hand in a piece of paper and have a copy made. They finally agreed to allow me on the property. I won't go through this whole thing. It took me from Tuesday to Friday to hand in my appeal, and it was Friday about an hour before they closed, an hour before my thing. I believe they purposely stalled me. I went in to get some public records, and they said, we don't have anything available until 2 days from now. When I went in to do either one of these things, there was a guy sitting at the front desk who was always there, who just did it. So they were just making this stuff up to make it difficult. So that part of the rule, it says that you can go in and do business with permission is crazy. They don't even know who the security coordinator is, and again, calling them is dangerous. I want to get it in writing. And to get something in email from them, it takes all week. And if you need a public record right away, or you need to speak before the commissioners and instruct them, I may know that morning. And they'll say next week, you can't do that. None of this can be done. How is the lens on a non-governmental camera more disturbing or harming than the lens on the county's cameras? If there is any chance that a law or rule could possibly take away the free exercise of any right, and especially those already protected by multiple documents, those laws or rules must have minimal standard of going through certain processes. There was no legitimate process in the case of the prohibition of the video recording, and there doesn't seem to be any process of the trespasses either. My trespass was improperly issued. If you look at Ian McGuire's warning, you will notice that Kelly Shoemaker and Jeanette Knowlton's signature on the trespass. If you look at Susan Hutt's warning, you will notice Ray Sandrock and Randall Sterling's signature on the trespass. If you look at this other trespass, you'll notice that only Randall Sterling's signature is on the trespass. He specifically says on the video he's doing it of his own accord. He says he has permission, but he had to get the signatures the next day. And the day before, he had to get signatures apparently, but not on the day that he gave it to me. That's just arbitrary. That's crazy. You have to have some kind of policy. They went to great lengths, the county attorney and Sterling, to say that she caused a disturbance because Ray Sandrock had to be interrupted in the middle of a meeting to sign a warning, which obviously he doesn't.
We've heard a lot about the U.S. Constitution. Everything Mr. Kessling said is for another form. This is not the place. And I've provided a memorandum on that issue. It's for you, sir. I've provided this previously to the magistrate, which addresses the issues to be determined today, and, unfortunately for Mr. Kesselring, this is not the forum for that, for the constitutionality of the issues to be decided. Well, he appears to be raising an issue that Mr. Winterkorn is a public official and has a right constitutionally, maybe not. I'm not going to concede it, but even if Mr. Winterkorn is deemed to be a public official under his interpretation, he was still videotaping from the moment he walked in the county administration building to the time he walked in Mr. Winterkorn's office, and that videotaping in and of itself is improper under the rules.